Standard practices that governments follow consistently from a sense of legal obligation may become customary international laws. Customary international laws were predominant at one time, but because they often lack precision about what constitutes sufficient evidence, treaties have become increasingly important. For instance, customary international law obligates a government to warn other states promptly about emergencies of an environmental nature and environmental damages to which other states might be exposed. A clear violation of this law occurred in August 1986 when a reactor at the Chernobyl nuclear power plant in the Ukraine exploded and sent a plume of highly radioactive material over large portions of Europe. At first, the Soviet Union released a brief public statement, less than 250 words, stating that an accident of manageable proportions had occurred. 3 days later, only after public satellites and radiation sensors in Western Europe revealed the true magnitude of this catastrophe to the world, the Soviet Union shifted its stance and began to provide accurate information. The Vienna Convention on Early Notification of a Nuclear Accident entered into force 6 months later to codify appropriate procedures for handling such catastrophes. International law holds a few truths to be self-evident and uses them to fill gaps between treaties, customary law, and judicial decisions. One of them is promises are binding. States have an obligation to act in good faith. They cannot take a position inconsistent with a previous one, especially when other states have relied on the early representation. This is the legal concept of estoppel. Another self-truth is that one should not benefit from one's own wrongdoing. A state seeking redress for the actions of another must come with clean hands. That is, a state guilty of illegal conduct has no right to complain about corresponding illegalities on the part of other states, especially if these were to counter its own illegality. A shepherd who has grazed too many sheep on the village commons cannot seek compensation if other shepherds begin to graze too many sheep. Another self-truth is that composition and application of rules should be just and fair. This is the legal concept of equity. Negotiations about mitigation of global climate change usually forward as a general principle that any permit system for greenhouse gas emissions should be equitable and take into account that states are at different levels of economic development and that their contributions to current atmospheric levels are highly disparate. Another self-truth is that governments should not gratuitously endanger the lives of people. The first case brought before the International Court of Justice involved this principle. In 1946, someone littered the Straits of Corfu off the coast of Albania with mines. British ships struck the mines, damaging the ships and killing naval personnel. The court declared that Albania, in failing to warn other shipping nations about the mines, had violated elementary considerations of humanity and ordered Albania to pay the United Kingdom compensation. The unauthorized release of environmental pollutants would be an analogous offense. The last self-evident rule is that widespread and systematic acts of persecution or atrocities against a group of people is a crime against humanity, the highest level of criminal offense. Violation of treaties that address global climate change are unlikely to fall into this category. The International Court of Justice states the decision of the court has no binding force except between the parties and in respect of that particular case. Nonetheless, the court itself and other judicial bodies often regard prior judicial decisions and writings of publicists as explaining the state of international law. In addition, arbitration tribunals and municipal courts, such as the United States Supreme Court, also serve as sources of international law, even though their decisions are not binding on other countries. Finally, declarations or resolutions of the UN General Assembly, even those that are non-binding, may provide another source of international law. In summary, climate change is inherently an international issue. Sources of international law are treaties, customs, general principles, judicial decisions, and legal teachings. General principles include that promises are binding, one should not benefit from wrongdoing, rules should be fair, and governments should not gratuitously endanger lives.